Good evening. This is Rahul Reddy. We're live here from Houston, Texas, from every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. We do take live immigration questions. Emily, what do we have today to discuss?
Yeah, today we want to talk about the latest that's going on with this F1 student SEVIS termination, visa revocations, what's going on in court. We've got some responses on our cases that are requesting a temporary restraining order. So we'll talk about that and some interesting updates that have been going on with it. We also want to talk about the alien registration, the G325R form that some people have to fill out. Not everybody has to fill out. Actually, most people that are here on an employment-based visa do not have to fill it out. So we'll talk about who needs to comply and what happens if you don't. Also, there's been article sharing that kind of makes it sound like all of a sudden you need to carry all of your documents with you at all times, even for H-1Bs and green card holders, and you'll be in trouble if you don't have your documents. So is it mandatory for you to carry all of your immigration documents or your green card when you're inside the US? And lastly, WhatsApp University is not USCIS. Be very careful when information is shared on non-official sources. A lot of times there's fake information in there, or it's not reliable information, or it's misunderstood, misinformed, miscommunicated. And so it's USCIS that makes decisions about status and immigration violations and things like that. So we want to make sure that you know where to get the official sources of news and updates so that you can stay informed but not panic.
Okay, we get to the hot topic of SEVIS termination. As everybody know that anybody with any police interaction, even if you have not paid the traffic ticket and you did not pay the traffic ticket on time and you got an arrest warrant, their service has been terminated. And of course, our dear partner, Mr. Stephen Brown, is been litigating in the court and is busy in the courts right now. Stephen, update that what is going on. Do you have any temporary restraining orders issued? What's the update? What is Immigration Customs Enforcement saying in the court?
Yeah, so we have cases all around the nation. So we started these on individual basis because, the concern is government's going to argue these are very individualized facts and arrests and everything. We secured last week TROs in Boston, in the Eastern District of New York, I believe one other.
Stephen, what is a TRO, please?
Yeah, a TRO is a temporary restraining order. It is an order from the court that prevents the government from a party, in this case, the government, from doing certain things. In our case, taking any negative actions regarding the SEVIS termination. It can be for 14 days. It is a very emergency initial motion, very high standard. Outside of those, we had a case, a TRO hearing in Arizona, where the government argued something very irrelevant, I think, to the merits of the case that we're trying to argue. We're trying to end around to challenge the visa revocation, not the status. And we can't. I fully agree. We cannot challenge a visa revocation. No immigration attorney would tell you that you can in federal court, maybe in removal proceedings, not in federal court. So that actually is interesting because we are going to be able to depose a member of ICE. I believe we're trying to work out the schedule for next week. And then over the weekend, we had briefs in Washington, D.C. that I think turned my understanding of what ICE's position upside down, because ICE has a lot of public statements that their litigation position does not match. I'm happy to address that in more detail, or if you want to kind of take a pause and explain what I'm saying.
So when in the cases where you got the temporary restraining order, let's say I have an EAD working on STEM OPT and OPT, does that mean I can continue working?
That's our position. Yeah, that that you will be able to continue on your status, at least for now.
You are telling me that the ICE, which is Immigration Customs Enforcement, which manages a civil system, um, told in the court to the judge under the perjury of law that when the student's status is not being terminated. However, we are getting the email from the DSO saying that they have to leave the country, their status has been terminated. That's what we are getting the emails from. Are they wrong? Are the ICE wrong? Or you are wrong?
Well, I'll go one step further. ICE, I think, disagrees with ICE's litigation position. ICE has on its website that when you have a SEVIS termination for a status violation, that you have no grace period and that you must apply for reinstatement or you must leave the United States immediately. This language and similar language is on ICE's website in a number of occasions on ice.gov, as well as Study in the States. ICE's litigation position, and I want to be very clear with what I am saying. I believe it is their litigation position because it's what they are saying in court, but it tends to not be in line with what ICE, what thousands of DSOs, what hundreds of immigration attorneys are thinking. ICE came in with a declaration from a official with Homeland Security investigations under ICE, saying that terminating a record in SEVIS does not terminate an individual's non-immigrant status in the United States. The statute and regulations do not provide SEVP the authority to terminate non-immigrant status by terminating a SEVIS record. And SEVP has never claimed that it had terminated individuals' non-immigrant status. They are also in court saying, well, yeah, judge, there's no harm. We have no irreparable harm, which is what we have to show in order to get a TRO, because he can work. He's lawfully present. He's not in danger of being put, into removal proceedings outside of an NTA. Nothing's wrong here. ICE's website tends to disagree with ICE's litigation position.
You are telling that they are telling in the court, this individual who is an STEM OPT or OPT can continue working based on the ICE affidavit that you have shown to me, if I'm not mistaken.
That's correct. It is.
And then, of
ICE
course,
affidavit.
the email from the SEVIS system from the DSO is telling that no, this person has to depart. And you're also telling that the ICE, which is Immigration Custom Enforcement, which controls the SEVIS system, says that if they are being out of SEVIS system, they have to depart the country. There is no grace period and they cannot continue. Of course, what does that mean is that they cannot continue working. So most probably these decisions will be made in the next 2 days, right, Stephen, where the judges will understand the law a little bit better?
I don't know if we'll get complete clearance because they're going to be presented with a record that's here, but we are going to continue to pursue. I've got hearings tomorrow. I've got to fly to DC on Thursday for a hearing. And I think into next week, we'll have more clarity as well. But we are currently re-evaluating our litigation strategy to account for this new curveball that may or may not be true as well.
So if I want to file a lawsuit right now with you, Stephen, what do I need to do?
Yeah, we have a Google form right now that we're using as a quasi.
I put that in the link in the YouTube.
Yeah, so absolutely. So we're using that as a landing page right now because I'm not as good with MailChimp as other people. So I'm using that as my kind of intake right now. And we will be emailing probably later this week. I'm hoping by Thursday, end of day, we can be like, hey, this is our new strategy. This is what we're going to go with. We're going to put together a call to discuss this and move forward and move quick.
So for those people who intend to take their cases to the court litigation, you guys can fill the Google Sheet out, and we are going to call you for a Zoom call, probably by the weekend or so. And what Stephen is telling that he will start in onboarding more litigation cases based on the strategies that we are learning with the litigation, what he has been doing from past 2 weeks, based on how the court hearings, what the immigration customs enforcement is telling, what the DSOs are telling, what the judges are telling. Based on that, you will be starting onboarding by the end of this week, or probably early next week. You will start taking more
Yeah,
cases.
maybe early next week, just holiday weekend. But we will be moving pretty quick. We'll start onboarding and moving quick on this. And I think we can pivot a little bit to, last week we were saying individual cases only, but we've gotten a lot more information in this past week. And that's kind of how I expected this to go, is that, we go surgical at first and then we can pivot as things develop. I mean, that's developing a litigation strategy for something that is very novel. I don't know about either of you, but I've only seen these emails starting April 3rd, from DSOs to students. I haven't seen anything before that. We're 12 days in, and we're getting a lot more information, maybe more questions in this.
Anything else, Emily, on this topic before we move to the registration?
Yeah, so I just kind of want to recap a little bit for people because there's so much going on. So, students are getting emails from the consulate saying a criminal records check, your name came up, we're therefore revoking your visa. And we've notified ICE, and you may want to depart and fill out this, your information in the CBP home app. So students are already, being incorrectly told that they need to leave the country based on that. And fear is coming into the picture because they're basically being told we're turning this over to ICE. Remaining in the U.S. without lawful status is a violation, and you could be fined and jailed and all these things. So they're creating the fear just by revoking the visa in this simple email. And then days later, they get a notification saying their SEVIS record has been terminated because their visa has been revoked, or because they've been, in this criminal records check. Some of them say otherwise failure to maintain status, all of these things. So the reason we're filing these lawsuits is because we feel that this SEVIS termination is unlawful. SEVP does not have the power to terminate SEVIS records just because someone's name shows up in a criminal records check. They've maybe been arrested, some not even arrested, some not even criminal activity, but maybe they've been arrested, but they haven't been convicted. They've just been charged. Cases are later dismissed. You're innocent until proven guilty. So that is why we are litigating. On top of the litigation, we are asking for a temporary restraining order so that the person's status can be kept the same. They can stay in status while we work this out in the court. And so some of those TROs have been issued, but at the same time, ICE is saying, well, we don't really need to give a temporary restraining order because the person's status is not in any danger, even though we've terminated their SEVIS record. So we're trying to figure out what is the impact of these SEVIS terminations on someone's status, on someone's ability to work when they're on an F1, and what is ICE saying about that, whether reinstatement is possible. This is all new areas of law, nothing that's been really litigated before. So it is very difficult to give people solid advice for their particular situation because we can't predict the future and how this is going to work out. So we'll hopefully have some more answers within the next week or so to give people some better guidance on what they should do if they're facing this situation.
Yeah, and I think you brought up a good point, Emily. I mean, I totally understand the student's frustration on this. I mean, I talked to a student today. He's like, how do I not have clear guidance on this? And I just, a week ago, we all were on the same page. And then ICE throws this curveball like, y'all, nobody knows anything. No immigration lawyer knows anything about F1. This is just a database. And, we're just kind of a new frontier here that we're going to be adapting to. So we're trying to adapt and keep y'all informed as best we can as we go.
So practically, my version is that initially, when we got the visa revocation, we said that you are completely in legal status because your SEVIS is not terminated. Then we started getting SEVIS termination. Then we said, if the SEVIS is terminated, you are not in legal status. You cannot go to school. You cannot work. Now we got an ICE which is stating in front of the court that these students are in legal status. They can continue working. There is no harm to them at this point of time. So these are all confusing statements coming out from immigration lawyers, immigration customs enforcement. So we will have more guidelines. And if you are interested in litigation, most probably on Monday or so, we're going to conduct a Zoom call where we will have interaction with Stephen Brown and Brad. So if you can fill out the Google sheet, if you're interested in your service is terminated, you can fill it out. Is that right, Stephen?
That's correct. Yeah, happy to help with this as best we can. Just sit tight. Like I said, I have hearings tomorrow. I'm in DC now on Thursday. That's how I plan my Thursday, and we'll be kind of keeping everybody updated as we go here with this. And I will note, Emily and I talked to a bunch of schools today, designated school officials, and the schools are definitely trying to get you guys as much information as they can, but they are very confused as well because this is brand new.
I want to go to the third topic, Emily, before we go to the second topic. Now, this WhatsApp University, I call it as, there are lots of rumors going on regarding SEVIS termination, people working at 2 jobs, people are getting deported because they work 2 jobs and H4EADs, all kinds of things, and what they should believe, they should not believe, Emily.
Yeah, I think a lot of these things people share maybe some basic information about what they heard without the full story. So, for example, we hear, oh, green card holder detained at the port of entry and sent back. Without the rest of the story, everyone thinks I'm a green card holder. I'm at risk of being detained at the port of entry because it happened to this person. But when we get into the real information, we find out there was a whole lot more to the story. And it wasn't just that green card holders are being detained. Like this person, there was a reason they were being detained. There was a reason they were questioned and sent back. So you really have to take any kind of stories like that with a grain of salt, especially when they're just shared on social media, until it actually gets shared in mainstream media. Even then, not all the information is shared. We're first hearing about H-1B holders being turned away at the port of entry, even though they have a valid visa. Well, come to find out there were other things involved with that had nothing to do with most people on an H-1B visa. So where do you get the proper information? Again, even with mainstream media, sometimes it does just generate fear and doesn't give all the information. Certainly on this channel, we do our best to share the actual information, the real stories of what's going on, what actually has a likely risk to people versus what happened to just this 1 or 2 people and under those specific circumstances. Certainly social media and websites of government agencies, USCIS, Department of State, Department of Labor, those kind of things. But I would say keep tuning into our channels, our social media here at our Reddy Neumann Brown, because we do share the actual information. We get to the bottom of it and figure out, is this something that you need to be worried about or not?
Emily, you pointed out that USCIS websites and all those things are genuine information. I respectfully disagree with you completely. And I have to, not respectfully, maybe, I don't know. And I will read out what is said in the Twitter from the USCIS, and which is being watched by millions. This is what it says for the registration. Please correct me if they are right, I'm right. Foreign nationals present in US longer than 30 days must register with the federal government. Failure to comply is a criminal punishable by fines and imprisonment.
Well, they did leave out some important points that a lot of people are already registered and don't need to register. So yeah, very good point there that even the government agencies are not sharing all the information.
That is from the USCIS website. And of course, I will go back to the emails that have been received for the visa revocation. When the visa has been revoked, you have to depart the United States, and they have been informed, and they have given the CBP application where they can report self-deport. How true is that one?
Yeah, absolutely. I mean, that says that in the email, but it's completely false. I mean, it says you may report your departure through the CBP app, but it coming from the government, it sounds very official that this is the step that I need to take, that I need to leave the US. And that's their goal, is to create the fear, get people to leave, and then not let them come back. But that's absolutely false. A visa revocation does not impact your status in the US. It just impacts your ability to come back into the US if you travel.
And this is, you're saying may, and let me read it again for you. What is said in the USCIS website, Emily? Not website, I mean Twitter, which is also official Twitter of USCIS. Foreign nationals present in the US longer than 30 days must register with the federal government. Failure to comply is crime punishable by fines and imprisonment. Now, when I'm pointing these things out to you guys, I mean, it is we have this WhatsApp University. We have the government that is also misleading us right now. The official government website, official government Twitters, they're also misleading. So you have to take with a grain of salt what information has been given. And you may need, just not us, there may be other immigration lawyers to interpret the things for you. What exactly does it mean? Now, of course, I'm going to come to the second topic, Emily. Does everybody need to register, must register, as it's been said in Twitter by USCIS? Can you explain who needs to file the G325R form?
So everyone needs to register, but the majority of people are already registered and therefore do not need to fill out this G325R. So how do you know if you registered? You are registered if you were fingerprinted when you got your visa at the consulate. I'm pretty sure anyone who's here in this country now who came on a visa, on a work visa, and are still maintaining their status, registered that way. But you are also considered registered if you have an I-94. So of course, people that watch this are familiar with that. It's the document that determines what status you entered in, what date you were admitted, and how long you can stay. So if you got an I-94 when you entered, you're already registered. So for the vast majority of employment-based legal immigrants who are watching this, the main people that need to register are kids who came to the US before they were 14 and then turned 14 while they were in the US. So if they already turned 14, they need to register now. If in the future they turn 14, they need to register within 30 days of their 14th birthday. Everyone else, for the most part, is considered registered if you have an I-94 or were fingerprinted during your visa interview.
For those people who have turned 14 after they entered into United States, if there have been biometrics have been done or not, if you have any doubt, go ahead and register them. And I have given a link to you guys where to go to register at the bottom of that. It is called G325. G325 form, R form. And I have also provided the information, examples of what columns need to be filled and how. There are a couple of columns that are a little bit confusing. What's intended? Why do you want to stay in the United States and certain other things? I've given some examples in the article I've written. There is also one question that is a little bit. It's not a little bit confusing. It is really misleading though. On what visa, on what status you entered into United States, it says EWI. That means entered without inspection. Practically, what does that mean is that This child has jumped the wall and came into United States, not through airlines getting the proper I-94. That's practically what EWI means. But of course, those people who are watching this one, almost all of them have entered legally in the United States. So there is a column where you can put it down. You can arrow it down and leave it blank. That one you don't put EWI. You leave it blank, and you can file this G325 registration. You can done it online. Stephen, you have any comments on that?
Yeah, just, I mean, to put a nice little button on it, I mean, I think 95% of the clients that we deal with are registered. I think the big things we're looking at are certain Canadian nationals and children who were registered and then turned 14. They have to re-register after their 14th birthday, within what, 10 days after their 14th birthday, 30 days, something like
30
that.
days.
30 days after their 14th birthday. So, you know, I've had a lot of questions on our Telegram. Oh, do I need to register? My mom came in on a B2. Does she need to register? She already did. It's just the language the government's using is very misleading, saying that everybody needs to register as if it's a separate step. The only people it's a separate step for are people who are not here lawfully, certain Canadians, and children who turned 14.
With regards to those people who are entered without inspection, jumping the wall, of course, most of our audiences are not, but you may have to consult immigration lawyers before you do anything on that. But as of our clients are concerned who entered into United States legally, and most of the audiences that we have, if you want to register the kid who has turned 14, even though he may have turned 14 long time ago, this G35R started only on April 11th. They have given up to 30 days. You can register online, and there is nothing there that you need a lawyer to fill it out. The web link that I have provided is good enough for you to cover and get the things resolved for you. Anything else, Emily, before we go to questions?
Yeah, the last topic I wanted to talk about is whether it's mandatory for you to carry your non-immigrant documents or your green card when you're in the US. And this stems from an article that's being shared that says, dated April 14th, new U.S. immigration order, H-1B, green card holders in U.S. must carry documents always. And they're talking about a ruling in court that said that, yes, people need to register. So again, it's, you know, I hate to say fake news, but they make it sound like this applies to everyone, and H-1B holders, it's something new and some new order came out, and that's just not the case. This is just, again, talking about that registration requirement, which most H-1B holders have already registered. Green card holders have already registered. There's no new requirements in terms of what documents you need to carry when you're in the United States.
Anything else before we go to Q&A, Emily?
No, that's it.
The gentleman is asking, I came on a bachelor's degree. Right now, I'm doing doctorate degree with the new I-20. The I-94 says duration of stated. Do I need to do a registration or anything like that? No, absolutely. You're fine. You don't need to file a G325R. The people are confused with regards to the traffic violations, guys. If you have got a speeding ticket and you paid the speeding ticket, that's not an issue, though. It's only those people who missed the speeding ticket and they got the arrest warrant. Stephen, you're correct. Go ahead.
Yeah, sorry. The theory that I am going off of is that when you are arrested, or maybe you're made to appear at the court or the police station, and you are fingerprinted as part of a criminal matter, most places also view speeding tickets as technically a criminal matter, even though they're not really crimes, okay? You know, what we consider crimes. It goes into a database. It goes into the NCIS database. It goes to the FBI database. We have heard Doge all about AI and comparing things. And what I think happened is you have SEVIS, which is a database, and you have NCIS, the FBI database, as a online database, you use AI, you say, where do these match? And then when there's matches, you terminate the SEVIS. That's what I think happened. That's why we see people who, hey, Rahul, I had a speeding ticket. I haven't got my SEVIS terminated. You're probably not going to. You might, but right now it seems to be there was this algorithm that was run. And that's, what my theory is. And then, I saw a couple of questions pop up on this topic. Hey, I had a dismissed parking ticket with my H-1B. Is it going to have any impact on my 485? We do not have anybody who's been on H-1B who said, hey, you got a traffic ticket, explain your status, right? Because H-1B holders are going to have a different level of scrutiny for them to revoke the status than flipping a switch for a database.
The question from Mayuri Jadhav, if the TRO, temporary restraining order, will we get back to work? Yes, that's the whole purpose for which Stephen is fighting or trying to get the TROs. That's the purpose for which he is trying to get it.
Ravi has a question on YouTube. We've entered the U.S. on April 11th and tried downloading the latest I-94 online, but it says record not found. What do we do? So first, I would try entering your name different ways. Take a look at the machine readable portion of your passport biographic data page and enter your name exactly as it appears there. That's usually the number one reason why I'm not able to get any records, is because the name shows up differently than how I would have entered it. Otherwise, if it's still not there, I believe CBP still has a form to fill out to contact for I-94 issues. If not, deferred inspection is the CBP office that can help with that. But I would try to do either that electronically through email. Some CBP deferred inspection sites do have email options, rather than going in there in person, just in the current
And sometimes what it is you have a new passport and that's your current passport, and your last travel was the old one. So the electronic I-94 is with the old expired passport, not the current passport you have. So try that too. That's usually the way I have to figure it out.
Bautik Patel, any effect of H-1B for speeding tickets with fine less than $500? If it's just a speeding ticket for less than $500, I'm not expecting any problem for user.
Is it safe to travel with H-1B stamping and pending I-485 to India? Look, I think if you watched any of our YouTube since January, we do not recommend travel. But in terms of abandoning your 485, if you are maintaining your H-1B status, you will not abandon it because you're on H-1B.
Ram says, I received my green card last year, May 2024. Do I need to contact the Social Security office to make any changes? Need, technically no, but should, probably yes. So usually before you are a green card holder, your Social Security card has a notation on it that says something like not valid without DHS authorization or something to that effect. That tells someone who, if you're applying for a job, you provide your Social Security card, they know that you need to provide proof of your ability to work, either your I-94, your I-797 approval notice, an EAD card. So that document plus the Social Security card combined prove your work authorization. Once you get your green card, you don't need separate DHS authorization to work. Therefore, you should, but you don't have to, but you should apply to Social Security Administration to get that notation removed. You don't have to, because again, you can provide your green card and your Social Security card that has the notation, and that's good enough for employment authorization. The reason I still suggest it is because we got into a situation a couple of years ago due to long processing times where people were, if I lost my green card or I filed for to remove the conditions of the green card, or I filed the green card renewal and the document expired while you are trying to apply for a job, now you didn't have that additional DHS document to go with your social security card, and people were not able to work, not able to get a new job. It's not a problem if you're at the same job, but when you're changing jobs, it became a problem. Whereas if you didn't have that notation on there, you could just provide your driver's license and your social security card, and you'd be fine. You don't need any immigration document. So for that reason, I would recommend it having that notation removed once you get your green card.
What? Oh, go ahead, Rahul.
I worked remotely for a product-based company with only 4 employees from the last 4 years. The employer has his employer address is a home address as a company location. Is it safe to travel for H-1B stamping? Absolutely not. That is a disaster ticket for the disaster, especially if you are if you're going for a H-1B stamping where the company address is a home address or a PO box. It's very unlikely that you'd get a visa stamping.
Question that I saw here, that TROs, temporary restraining orders, are just that, temporary. What happens during the pendency of the case? Well, temporary restraining orders can only be for 14 days. For good cause, they can also be extended. We would also eventually be seeking, if we get a TRO, a preliminary injunction, which is more longer term. The idea is this: the underlying idea for TROs and preliminary injunctions is to maintain the status quo while the lawsuit is pending, because otherwise there will be substantial harm that money can't fix. And that's kind of what it is. And so I think if we have success on these will work out as things continue.
Can we reach out to USCIS for H4 extensions? Or my H4 has crossed the processing time? Yeah, absolutely, you can. And practically, you don't need H4 extension unless you have an EAD attached with it, because you can stay in the country when the H4 extension is still pending. But yeah, you can contact if it crosses the processing times. I have a bad credit. Can I lose my F1 and have a problem while traveling? I don't see that bad credit is an issue at this point of time for F1 visas. I definitely recommend not to travel outside the country, though, if you have some bad credit. Abid Ahmed, are you considering SEVIS litigation cases for simple assault and that has been dismissed? Yes, Stephen is considering that, definitely.
Yeah, I think what we're going to be looking at is 2 groups of people initially, and then kind of different for a third group. So, people that have simple traffic type tickets. I had somebody, their license had expired. They paid a $25 fine, Rahul, and they still had to go to court, get fingerprinted. That's kind of one bucket. Another is you were arrested and dismissed. You do not have a criminal record if they didn't bring charges or dismissed. The third bucket is people who were arrested, have a conviction or a plea that they did it. That would probably be a third grouping that we're going to look at very differently, because I think those are very different analyses.
Mariam Dasti has the question, for the temporary restraining order, that is the crime involved, is that going to be matter for the temporary restraining order? There are some inadmissible crimes. For example, if it is drug-related, high drug-related crime, or if it's a domestic violence, they are crimes against moral turpitude crimes. These are major crimes that are involved in. Definitely, that will play a role on the judge whether he will issue a temporary restraining order. So definitely, if it's a major crime, I would definitely avoid going to court at this point of time.
Janum says, my parents are on green card for the last 4 years. They're returning after 9 months. Will they have to justify why they were out for an extended period of time? Yeah, those are the type of people that are running into trouble at the port of entry. When you are a green card holder, you're supposed to be permanently residing in the United States and taking temporary trips abroad. 9 months is not temporary. Anything over 6 months is not temporary. So they need to be able to convince the CBP officer that they did not abandon their green card due to this extended stay outside the US. And there's definite risk there.
Stephen, question for you about the H4 EAD delays. Though you did the class action and that ended in January 18th of 2025. If my H4 and EAD has been pending for a long time, what do you have anything where we can go to court, or how does it work out?
Yeah, I I always tell both of y'all, I don't want to fight these again, solely because I'm hoping the administration doesn't make the same mistakes they did the first time. But we're prepared. I have filed H4 EAD delay cases for standalone since the Edikuni settlement, that were separated out, from the H1B filing. And I think we can do it. Again, my hope is we don't have to, because we're not seeing the long processing times again. But we can, and we're ready, and I've got it, ready to go if we need to.
People are asking, by filing the temporary restraining order, does that protect in all senses? Not filing. I mean, filing the court case by itself is not going to protect you. It's getting the order from the judge in our favor is what required for us. So that is what we will get the OPTs, term extension, or get back to school. Those things will be achieved when we get the judgment in our favor.
Garrick says, is an H-1B holder eligible to own an LLC? Potentially. So if you think about owning an LLC, similar to owning stock in a company, where all you do is own the stock in the company and take the profits or dividends that are paid out by the company, you can own a share of Microsoft stock. That's totally fine. If you're doing that with an LLC, you can own a portion of the LLC or the whole LLC, as long as you are a passive owner. You're not actually working for the LLC. You're not doing any kind of the administrative tasks. You're not running to the bank. You're not, if it's a restaurant, you're not going to the restaurant and helping, serve tables or anything like that. So you can own an LLC while you're on an H-1B, but nothing beyond that. But even if you just own it and aren't doing anything beyond that, it does raise the level of scrutiny. We see a number of times at the 485 stage that the interview officers don't understand the difference between being an owner and an employee. And so they're going to question whether you maybe worked without authorization because you own this company. So you need to have really good documentation of who's actually running the company and who's working for the company, so that you can prove that you did not work for the company.
Augustine just asked a question. Some non-citizen authors have expressed concern for their immigration status over expressing opinions critical of the administration, even if unrelated to Palestine. Is this concern merited? I have not seen them take a true First Amendment swipe at things. The issues with the protesters with Palestine, setting aside the First Amendment, is that under the Immigration and Nationality Act, the Secretary of State can make a determination that any non-citizen has, with presence in the United States, is conducting themselves in a way that is harmful to the U.S. foreign policy. Because of our diplomatic ties with Israel and our stance on this as a country, that is very different, I think, than being critical of the United States government. That is, the United States government is not foreign policy. I don't know. What do y'all think? I tend to.
It's been over reaction of the press that if you criticize Trump, they are going to take your green card off, H-1B off, F-1 off. Absolutely not true. We are
Again,
critical of Trump. I am critical of Trump all the time, and most of our audiences are. No, that's not true. As it was a single isolated, that is particularly that particular person have conspired to prevent some people to go to Columbia University classes. So there are a lot of issues with that particular individual, though. So that is not applicable for 99.9% of the people. So don't live in the fear. You can express if you like Trump administration, go ahead express it. If you don't like it, go ahead express it. If you like Rahul Gandhi in India, go ahead express it. If you don't like Modi, you can express it. Or you like Modi, or you don't like Rahul Gandhi. That will not have no effect in your immigration status in the United States. So please don't live in that fear.
Yitika says, my parents came to the U.S. on April 9th, planning to stay for 38 days. Do they still need to register with USCIS? Well, I'm assuming your parents had a B2 visa stamp in their passport. So when they got the visa, they would have been fingerprinted. That means they're already registered. They also, when they came into the U.S., they would have been issued an I-94. Getting an I-94 means they're already registered. So even though they're going to be for more than 38 days and you have to register it when you're in the US for more than 30 days, they already registered because they got the visa and they got an I-94.
Question from Jamil on YouTube. I'm on OPT and the crime that I was charged with got dismissed. My school not issue a reinstatement I-20 because I am not registered in courses. Should I sue or leave the United States? Look, that's an interesting part on the reinstatement. I do not think they can do reinstatement for OPT. I think you have to be in class to get reinstatement based off of the plain reading of the regulation. Whether you sue or fight is totally up to you. I understand people that are wanting to leave. This is very unfriendly administration right now. I get it. I think leaving will be hard to come back if you do not fight now. But that's going to be a decision you have to make, as an adult here.
My wife has an ED-1B approved I-140. She is a CAP exempt right now. That means she's working for a nonprofit higher education institution, most probably. If she changes the job, is she still CAP exempt? No. The new organization also must meet the requirement for CAP exempt. So if you're moving from organization A to organization B, the organization B should meet the requirement of the nonprofit and the higher education institution. Otherwise, you will have to go through the lottery system. Stephen, question for you. How long does a lawsuit take? What is the prediction timeline for the temporary restraining order, permanent injunction, and permanent resolution?
I filed cases Thursday, Friday, and I'm in court all week. I had 2 hearings Monday, a hearing today. My co-counsel is in LA on a hearing. I have 2 hearings tomorrow. I have a hearing Thursday in DC. I have respectfully asked judges to let me not have hearings on Good Friday, but I will be there if needed. We're only a weekend and we're in court. Decision wise, up to the court. What the decision is up to the court. Again, the decision today of we can't give a TRO because there's no harm because ICE says you're in status and all that. That's actually kind of a win, right? Because they're saying you're in status. So we're moving pretty quick. We are retooling our strategy, but I think we're feeling pretty good about it. From this perspective, again, being in court within a week on this is good.
Pooja Mahal.
Ahmed says, my H-1B was automatically revoked. Was that because I re-entered the U.S. on advanced parole? No, that would not. Entry on advanced parole does not have any impact on your H-1B petition approval. Automatic revocation of an H-1B is most likely when the employer sends a withdrawal request. So if you don't need that petition anymore, an employer will notify USCIS that they're withdrawing the petition. That results in an automatic revocation. Most every other kind of revocation of an H-1B petition is not automatic. They have to first send a notice of intent to revoke, telling the employer why they plan to revoke and giving the employer an opportunity to respond. And then only after that response, they have to then make a decision about whether they're going to revoke or
Emily,
not.
there is a video that has been circulating that all these SEVIS termination people, the ICE is coming and picking them up and putting them into Guantanamo Bay or whatever. How much truth is in it?
Thankfully, none. I mean, we're talking to hundreds of students in this situation, have not come across any situation where any of the students have been picked up, detained, tried to be removed, sent to detention or anything like that due to these particular SEVIS termination issues. Now, there are other situations that have a lot more factors involved that are not the typical situation. So for those that have the SEVIS record terminated because their name came up in a criminal records check, we do not anticipate them being detained or picked up by ICE at this time.
To add to that, Emily, while we have been here, I just got the brief from the government on the hearing that I have at 9:30 tomorrow morning. The government says prudential visa in their declaration, prudential visa revocation and SEVIS termination, absent other factors, does not make an individual amenable to removal. So, to your point, it would have to be these things plus something that makes you removable. And I agree with that position. What I don't agree, with is that ICE is saying something about being unlawfully present online. That is different. But if they're going to take this position, but I'm on the Reddit, Emily, Rahul, with F1, I'm seeing this. I'm keeping up with this. I have not seen a single person get a knock on the door from ICE, get picked up, or anything. I think if we see that, we will go live. I am sure there are attorneys who have because of other issues involved, but I have not seen anybody who, I got a traffic ticket that was dismissed, my SEVIS was terminated, now I'm in immigration detention. It's not happening.
Ji Yeon says, do you deal with H-1B entrepreneur cases? Yes, we do. And this is based on the January 17th, 2025 regulation that modified the ability of entrepreneurs to have their own company file and sponsor the H-1B petition. There are still some restrictions and requirements on that. The petition can only be approved for 18 months instead of the typical 36 months. The company still has to be able to pay the prevailing wage, and you are limited in your job duties to an extent. You need to be spending the majority of your time doing specialty occupation work and less of your time running the business, doing the administrative side of your work. But we are filing them. We are getting the approvals of them. We have not seen a lot of issues in getting those cases approved.
Abhijit is asking the question about the green card holder, port of entry rights and other things. It's been over. I mean, you guys are living in a lot more fear, guys. Please do understand that if you are normal, typical Tom, Dick, and Harry green card holder, you're traveling to your home, you're traveling outside the country, you will have no problem coming back at all. There are two set of people that need to be worried about. If you are traveling outside the country and you're staying more than 180 days outside the country, definitely I want you to check with the law. Sorry.
Yeah, I mean, look, how many thousands of people travel every day versus how many people have expedited removal at the port of entry? It's disproportionate amount get admission versus have issues. And we talk to hundreds of people a week that travel, no issues, and a small number that have expedited removal because of other things. I agree with Rahul. I think we can't all live in fear all the time for the next 3.5 years. 3.5? Can I say that now?
Yeah. Less, more than that. Yeah,
Yeah,
and then
just about.
I said two set of people. One is the people who are going more than 180 days outside the country. I definitely want you to check. The second set of people are if you have anything other than speeding tickets and parking tickets, if you have anything other than that, you have any criminal records other than that, definitely you may want to check with an immigration lawyer before you travel. These are the only two kinds of people. If you have just a speeding ticket or a parking ticket, or don't worry, don't bother calling us and checking with us, guys. You're fine. Absolutely, the green card holders can travel, have no issues, none whatsoever at all. If you have travel plans for more than 180 days, or if your relative who's a green card holder is coming after more than 180 days, then definitely check with a lawyer. In fact, I see some person is coming after 9 months. His mother is coming after 9 months. And yes, uh, after she has gone to India, she's coming after 9 months. That definitely is a thing that you need to check with a lawyer. There are some precautions that you need to take because a green card holder is called as a permanent resident of United States. You are supposed to reside in USA and you can visit other countries. But if you're acting as if that you are staying in another country, you're visiting, they may terminate your green card though. Now, you are supposed to file income tax returns every year. Then you may ask the question, my mother does not make any money. How can she file income tax returns? You can put 0, 0, 0, net income, gross income, everything 0, 0, 0, 0, and you can file income tax returns. Absolutely not a problem. But you have to file income tax returns. Every green card holder is supposed to file income tax returns. So there are certain norms. They have to maintain a residence in the United States, especially if your mother is coming after 9 months. I want all the income tax returns to be filed. I don't want her to come here on a written ticket. If she's coming on a green card, I don't want her to come on a written ticket. I want one-way ticket for her to come. There are certain steps that you need to take before she comes to the United States. But other than these two categories, you're good.
On that, today's tax day. File your if you haven't filed your taxes, make sure you file your taxes or file your extension. That is my tax knowledge that I will share.
To file.
Vimo 11 has a good question to wrap things up here. Can this visa revocation trend for F1 visas be carried out on H1B visa holders too, or other visa holders? Yes. So the Department of State has very broad authority to revoke a visa after it's granted. So remember, we're talking about the visa that's stamped in your passport. When I say visa, I'm not talking about your H1B approval or your L1 approval. I'm talking about the actual visa stamp in your passport that has your picture on it, that has the H1B category and the end date and those sorts of things. Department of State under 221I can revoke a valid visa at any time in his discretion, and you cannot go to court to get that overturned. So yes, if H1B holder has been convicted of a crime, been arrested, they could also receive a notification from the consulate saying your visa has been revoked. That's been happening for a number of years. It's not anything new. It most commonly happens in the event of a DUI or DWI, because they want to make sure that if you leave the country, you have to apply for a new visa, go through medical panel to make sure that you're not a habitual drunkard or have alcohol problem, which are grounds of inadmissibility. Now, can the SEVIS termination or termination of status of F1 be carried out on other visa holders as well? That is more difficult for the government to accomplish because you can't just terminate an H-1B visa status. The only way you can do that is to deny an extension of status, deny a change of status, or issue a notice of intent to revoke the approved petition. Has to be given notice first. They have to give you 30 days to respond. And then after you respond, then they could potentially revoke the status. But it requires a lot more work on the part of the government, many more steps involved. And so we're not expecting them to do that for every single H-1B holder who's ever been arrested. But as far as visa revocations, I do think that's something that they could do.
Anything else, Emily, before we wrap up?
Definitely, again, stay tuned to our channel here so that you get the latest updates, hopefully without the fear, without the panic, and can get the real information versus the sometimes wrong information that you get even from the government websites, as Rahul pointed out earlier.
Thank you very much for tuning.